Call the meeting to order. This is meeting number 45 of the Standing Committee on Justice and Human Rights. Today is Thursday, February the 2nd, 2011. You've got before you the agenda for today. We're continuing our review of Bill C-54, an act to amend the Criminal Code, sexual offences against children. To assist us with our review, we have with us again our Minister of Justice and Attorney General for Canada, the Honourable Rob Nicholson. And accompanying him are senior officials from the Department of Justice. We have with us, first of all, Carol Morency, Acting General Counsel, Criminal Law Policy Section. And of course, we've also got Donald Pirgoff, Senior Assistant Deputy Minister, Policy Sector. So welcome to all three of you. And joining them will be Matthias Villetort, Counsel, Criminal Law Policy Section, once the Minister leaves. And also a reminder to all members, if you could provide any proposed amendments to the clerk, because we're hoping to move to clause by clause the second half of the next meeting, which is Monday. Now that might carry over into the following day, which would be Wednesday. In any event, if you could get those amendments to us, it would be very helpful to the clerk, the rest of the members.
Vous signalerez que de cela, on devrait en discuter.
I didn't know that we would have to discuss this during our I think we should discuss this at the steering committee meeting.
Monsieur Menard, please.
I feel that this is something we should discuss at our meeting tomorrow.
Steering committee.
The steering committee meeting.
Discuss it at the meeting, the steering committee tomorrow.
Yes, we intend to discuss that at the steering committee tomorrow. We want to make sure everybody's got lots of advance notice that we would like to see your proposed amendments. And as you know, tomorrow we'll be discussing the calendar going forward, exactly how those meetings will play out. In any event, we've got the Minister with us. Minister, you've got 10 minutes, and we'll open the floor to questions from our members.
Merci beaucoup, Monsieur le Président. Je suis heureux.
Thank you very much, Mr. Chairman. I am very pleased to appear before the committee as you begin your review of Bill C-54, the Protecting Children from Sexual Predators Act.
As you begin your review of Bill C-54, the Protecting Children from Sexual Predators Act, our goal with this bill is twofold. First, it seeks to ensure that all child sexual offenses are treated seriously and consistently for sentencing purposes. Second, it proposes reforms that seek to help prevent the commission of sexual offenses against children. Now, this bill's sentencing reforms target mandatory penalties for all sexual offenses where the victim is a child. The sexual abuse of any child is a serious offense, and it must be clearly denounced. Our government believes that child sexual offenders must receive sentences that reflect the seriousness of their crimes and the danger they represent to our children. As members of the committee will know, acts of child sexual abuse can be charged under child-specific offenses or under the general sexual offenses that apply to both adult and child victims. Though these two groups of offenses address similar conduct, they do not impose similar penalties where the victim is a child. For example, some of the child-specific sexual offenses impose mandatory minimums, but none of the general sexual offenses impose mandatory penalties. In addition, the variations in sentencing often results in conditional sentences of imprisonment or house arrest, as it's often referred to, for some offenses but not for others. The effect of this varying treatment is that not all child sexual assaults are treated equally seriously by the system. In fact, given that 80% of police reported incidents of child sexual assault in 2008 were charged under the general sexual assault offense in Section 271 of the Criminal Code, this means that the overwhelming majority of child sexual offenses do not carry a mandatory minimum penalty. This bill changes that. There are currently 12 child-specific sexual offenses that impose mandatory penalties. Amendments made in 2005 to those offenses resulted in mandatory penalties being added to only some of the child-specific sexual offenses and to none of the general sexual assault provisions. These changes produced a random and inconsistent approach to mandatory penalties such that they do not all adequately reflect the serious nature of the offenses. Now, in order to fix these inconsistencies and ensure that sexual predators receive sentences which reflect the extreme seriousness of their crimes, this bill proposes to add 7 new mandatory penalties to offenses that currently do not impose mandatory sentencing. 3 of these are child-specific offenses. One of them is the bestiality provisions, the other one is the internet luring a child, and the other is exposure to a child under 16 years of age. The other 4 are general sexual offenses, and the mandatory penalties will apply where the victim is a child under the age of 16, the age of consent. They are Section 155, incest, 271, sexual assault, 272, sexual assault with a weapon, threats, or causing bodily harm, and 273, aggravated sexual assault. This bill proposes higher mandatory penalties for 7 child-specific sexual offenses that already carry mandatory penalties. This will ensure that the mandatory penalty is commensurate not only with the offense in question, but is also consistent with other mandatory penalty offenses. For example, C-54 would increase the current mandatory penalty for Section 151, sexual interference, which carries a maximum penalty of 10 years on indictment, from 45 days mandatory to 1 year mandatory. In this way, the higher mandatory penalty would be consistent with the new mandatory penalty proposed for Section 271, the general sexual assault offense. C-54 also seeks to prevent the commission of a sexual assault against a child. It does so by proposing the creation of 2 new offenses and by requiring the courts to consider imposing 2 new specific conditions that would seek to prevent a suspected or convicted child sex offender from engaging in conduct that would facilitate their sexual offending. The first new offense proposed in this bill would prohibit anyone from providing sexually explicit material to a young person for the purpose of facilitating the commission of a sexual offense against that child, okay? For the purpose of facilitating the commission of a sexual offense against the young person. Child sex offenders often provide such material to their intended victims with a view to lowering their sexual inhibitions. In other words, they do this as part of their grooming process of the victim. Today, if that material constitutes child pornography, irrespective of the purpose, it is already prohibited. C-54 does not change that. But where the material in question is not child pornography, in other words, where it depicts adults engaged in explicit sexual activity as defined by the new offense, the criminal code does not currently catch this unless the material meets the very high threshold definition of obscene material under Section 163. C-54 will change this. It proposes to prohibit providing sexually explicit material to a young person for the purpose of facilitating the commission of a sexual offense against that child. And this new offense would carry a penalty similar to that for the existing obscenity, corrupting morals offense in Section 163. C-54 also proposes to prohibit anyone from using telecommunications, such as the Internet, to agree or make arrangements with another person to commit a sexual offense against a child. In addition, this bill proposes other needed consequential amendments, including, for example, adding the two proposed offenses to Section 7.4.1 of the Criminal Code that provides Canadian courts with extraterritorial jurisdiction to enable the prosecution of Canadian child sex tourists. Both of the proposed new offenses would carry mandatory sentences of imprisonment. Lastly, our bill proposes to expand the powers of the court to prohibit a convicted child sex offender under Section 161 and to prohibit a suspected child sex offender under Section 810.1 from engaging in conduct that may facilitate their commission of one or more of the enumerated sexual or abduction offenses. First, the list of offenses would be expanded to include four prostitution offenses where the victim is a child. Second, the courts would be specifically directed to consider imposing a condition prohibiting the offender from having any unsupervised access to a young person and from having any unsupervised use of the Internet. The imposition of these conditions would help to prevent the offender from being placed in a situation where he has access and opportunity to sexually assault a child, and from having unfettered use of the Internet and other technologies that are so instrumental in the commission of child pornography and other child sexual exploitative offenses. These are the key elements of this bill. Like all law-abiding Canadians, our government knows that the sexual exploitation of children causes irreparable harm to the youngest and most vulnerable members of our society. Our message in Bill C-54 is strong and clear. To those dangerous sexual predators who abuse children, from now on, you will go to jail. Thank you very much.
Thank you, Minister. We'll begin with Mr. Murphy for 7 minutes.
Thank you, Minister. Thank you for your overview of this bill. Curiously, we had witnesses before. We had you, and one of the witnesses, Mr. Rushfelt, was very interesting in terms of his and his group's submission. I've spoken to Nathan Cooper as well from that group about the definition used in Section 163.1 as it relates to child pornography. So I'll turn your attention to that. In fact, he suggests, although applauding the bill in general, that the definition should more accurately reflect what is depicted in what is being trafficked or used, and that is, to use their words, child sex abuse materials, because those images depicted are abuse. They are rapes, they are attacks, they are the most heinous of crimes, which leads me to this question. Your spokesperson, I don't know if she's a lawyer or not. I don't know if she's schooled in these sections of the code. But your spokesman said that the definition of child pornography found in 163.1 is among the most comprehensive in the world and leaves no doubt the heinous crimes are illegal. I guess my point is I'm struck by the evidence of the people who work in this field. I think you have some empathy for them as well, that the images actually are child sex abuse materials, which is a stronger, I think, definition than as it is defined under 163.1, child pornography. And if the crimes you're seeking to accelerate or increase the penalties upon are very serious crimes, they ought to be accurately reflected. I wonder, therefore, that's my first question, if you would be open to the idea of maybe not in this bill, maybe it's outside the scope, but amending the definition, or whether you stand by your spokesperson's words in this regard. As these things tend to go long on answers, Mr. Speaker, because you're so, or Mr. Minister, because you're so eloquent in your responses, I'm going to load you with another question. Why didn't you bring this bill sooner? This isn't the usual case where this is a regurgitation of another bill, and I wonder why it took so long. You made much, frankly, of saying that everybody blocked you all the way and that Liberals are new to this crime deal and all that sort of garbage that you say in the other place. But, you know, I've been here 5 years and I don't remember this bill. I would have really liked to have seen this bill. I've been talking to Nathan Cooper for 3 years or 4 years, and I haven't, speak for myself here, blocked you every step of the way. I haven't, Minister. So why not sooner? And would you be open to this, or I'm interested in your comments on the definition child pornography versus child abuse material, child sexual abuse materials?
Yeah. First of all, in answer to your question about child pornography, no, I would oppose any plans to change that. That is the bill that has been litigated and defined and considered by the courts of this country. That is the term that is used in all my international discussions with other G8 justice ministers. This is the term that is used at the United Nations, and the term child pornography goes beyond just the depiction of child sexual abuse images. It's broader than that. I can tell you the definition includes not only images depicting actual sexual abuse of a real child, but also the depiction of such abuse of an imaginary child, images that do not depict the sexual abuse of a real or imaginary child, but which depict a child's sexual organs for a sexual purpose, written or audio material that advocates or counsels unlawful sexual activity with a child, written audio material. It's considerable, it's larger, it's part of the lexicon of our legislation in this area. I am not prepared to change that because I believe that that would restrict what we are talking about. Now, with respect to that, you, I'm sure, would be very aware how difficult it is to get any piece of legislation passed. I had legislation that we took for about a year and a half that included provisions to protect 14 and 15-year-olds for the first time since the 1890s, to protect them against child sexual abusers. And you would be aware of the fact that there are members of your caucus that were tripping over each other to get in front of a camera to say that there was somehow...
They must have tripped over you on the way. Just talk about this bill. Why so long?
But you're saying why now for this bill?
Yeah, 5 years.
I'm telling you that it's very difficult to get anything, even protecting 14 and 15-year-olds. We are in the business of protecting children from child sexual abuse. I have another bill requiring Internet service providers. I'll say get those bills passed, and I promise you that we will continue to make strides in protecting children and continuing to protect this country from violent criminals. So it's not easy. Let's get this bill passed. Let's get the other bills passed. But as I say, you and your colleagues, I'm sure you talk about this at caucus, of all the efforts that are made to slow down these bills or to oppose them
back to the bill?
or to challenge them on. It's a challenge, Mr. Speaker, but I'm going to tell you something. I'm proud to be a part of a group of individuals who have made this a priority, and we're going to continue to push until this is the law of this country.
Make your speeches elsewhere, Minister. Abuse is actually not in 163.1. That's why I was asking it, but I'll leave that for the technocrats who actually know the stuff. I want to ask you about Inspector Naylor's comments yesterday. He seemed a very forthright, upright law enforcement official. And he suggested that, we could always use more tools. Obviously, he was in favor. This is about the telecommunications aspect of making arrangements to commit a sexual offense. Very nice part of this legislation. And we were reminded that C-46, I think it was a bill that lived until your government killed it through prorogation, which would have given investigative powers. Can you tell me where we are with that and whether you want to, you could get, if we could all just lower the temperature on the hyperbole, I guess. Well, there's a mea culpa there. I know you're laughing because you always do there, Bob, but the point is we want to get some things done. This is a good bill to get done. So is C-46. Where is it?
Well, it's known, I think you've got the wrong number. It's C-51.
Investigative powers.
Investigative powers for the 21st century. And certainly I'll pass on to the House Leader that you're very anxious to get that bill passed.
51.
And this would be certainly a beautiful thing. So, yeah, I've talked with law enforcement agencies, and updating the criminal code with respect to the investigative tools within the criminal code are very, very important to them. As I've said before, Mr. Chairman, criminals don't just phone each other anymore more. They've gotten out of the habit of sending telegrams to each other. And so the laws of this country have to be updated to reflect the current state of technology. And so the bills that we have with respect to lawful access and investigative powers are another priority for this government. And again, I'll pass on to the government House Leader how anxious that some members of the Liberal Party apparently are to get this passed. And I say hang tough in there and let's get those bills passed.
Thank you. We'll move on to Monsieur Menard for 7 minutes.
Thank you, Minister. I feel that this is a bill that matters a great deal to you. During your presentation, I was noting down the various categories of crimes that are being created, the various sentences. Could you summarize in saying, in this bill, how many offenses, how many sentences, rather mandatory minimum penalties are imposed under this bill?
I believe there's 2 for the new offenses, 7 that have been included, and I believe there's another 9 of it. Pardon me? 7 increases. Yeah, there's an increase of 7 altogether, Monsieur Menard, for which there may not already be a mandatory penalty.
Puis dans les nouvelles qui sont créées,
And what about in the new ones that have been created?
Yes, there are mandatory penalties with respect to the new ones as well
combien?
How many?
that have been created under this bill.
Okay. There's an association called, I have the name here, the Council of Churches for Justice in Criminology, who wrote to the Prime Minister on December 17th regarding this matter. Did you read the letter they sent to the Prime Minister?
I don't have a copy of the letter.
Est-ce que vous l'avez lu?
Did you read it?
Non?
I don't have a copy of the letter.
Je n'ai-
To me,
Non, le Premier ministre n'a pas cru
Right.
bon.
The Prime Minister did not,
your question.
Le Premier ministre,
did the Prime Minister send it to you?
Conversation that I have between the Prime Minister and myself, I'm not going to repeat, but if you have a question about it, I'd be glad to answer.
oui, je me demande si vous l'avez eu.
Yes, I'm wondering if you received the letter.
My understanding is the letter was sent to the Prime Minister, and I'm aware of the letter, but
Bon.
if you have any questions about it, please ask.
Donc, c'est ce que-
That's what I wanted to know. So you're aware of this letter, you're aware of its content. Can you give us some comments on the content of this letter?
I'm glad to have input all the time, glad to have suggestions on any of these. We look forward to getting input from a wide range of individuals. We certainly have that. And if it's your intention to call that group before here, you're certainly welcome to do that.
Ce n'est pas ce que je vous demandais. Je vous demandais
That's not what I was asking. I was wondering what your comments were on this letter that you are saying, of which, that you know about the contents of.
And I appreciate the comments, and my thoughts and are completely reflected in the bill that you have before you. And there's one thing that you and I will agree on, Monsieur Menard, is your initial comments that this bill means a great deal to me.
Bon, dans le titre que
Okay, this legislation has a title. So, an act, Protecting Children from Sexual Predators Act. I always hear you referring to children when I hear you referring to this bill, but there are a number of provisions that in fact apply to adolescents and young people.
Well, that's true.
bon. Mais vous insistez toujours.
But yet you always focus on the word children. Why not provide a title that is a better explanation of what it is?
I mean, we can argue whether if you're arguing whether 14-year-olds are still children, or 15-year-olds, or 13-year-olds. If you prefer the title young people en anglais, I don't have a particular problem with that. But what we're doing is zeroing in on children. As a matter of fact, what law enforcement agencies have been telling me is that the images, quite frankly, are getting younger all the time on that. There are approximately 750,000 pedophiles online at any particular time. There are millions of images, and they tell me the trend over the last 10 years, believe it or not, is to keep getting the images of younger people being exploited, younger children. And so, again, that is where we're zeroing in on.
When you arrived at the Department of Justice, I think it's 2006, the department had commissioned a study of Mr. Julian Roberts on mandatory minimum penalties imposed in other Commonwealth countries. He produced his report in 2006. Are you aware of this study?
I'm aware of it, yes.
Bon. Alors, vous reconnaissez.
So, you'll acknowledge that, just like in the case of this letter from the Canadian churches, Mr. Roberts points out that the imposition of mandatory minimum sentences in Commonwealth countries has not led to a decrease in the number of offenses meant to be dealt with through these mandatory minimums.
First of all, I didn't come to the Department of Justice 2006. It was 2007, just a little over four years ago. Now, I'm aware of a number of reports. Sometimes I'm told that the Americans have very tough mandatory penalties in this area. There are a number of Commonwealth countries that don't have mandatory sentencing. This is a Canadian approach. I think it'll work. Mr. Menard, I hope this gets your support, because we're protecting the most vulnerable people in society. And I appreciate that there are those, including yourself, that don't like mandatory penalties. But again, we have to send out the right message. The problem is getting much worse over the last few years. This is what law enforcement agencies have told me. They tell me that the number of images, for instance, since 2003 have quadrupled. Since that particular period of time, all of them depicting children being abused and exploited on the internet, and we have to take action on that. So the problem hasn't been getting better these last 4 or 5 years, and this is exactly what we need. And I want you to have a particular look at those new offenses that are in the business of preventing this kind of activity. Two people getting together to discuss setting up a child, or the person who gives sexually explicit material to a child. These are designed to stop the child's sexual exploitation before it reaches its inevitable conclusion. And so intervening ahead of time, again, in my opinion, is updating the law, and is exactly where we have to go. And so the problem has gotten much worse in the last few years, and we need legislation like this to deal with it.
Thank you. Before we go to Mr. Comartin, just a reminder to members, if you could move your Blackberries away from the mics so we don't have that interference. Mr. Comartin, 7 minutes.
Thank you, Mr. Chair. Thank you, Mr. Minister, for being here. I want to go back to Mr. Rushfeld. When he was here, he indicated that about a year ago his agency submitted a brief to your department and never got a response. Mr. Rushfeld, when he was here from the Canada Family Action Coalition, that they had submitted a brief to your department about a year ago and never got a response. And it's on the same issue that Mr. Murphy had raised. So I guess my first question is, are you prepared to make that brief available to the committee so we see it? When Mr. Rushfeld was here, we asked him for some other information. We didn't ask him for the brief.
I'll certainly check into that for you, and I'll find out why there hasn't been a response to that.
Right. But would you also provide a copy of the brief to the committee?
I have no problem with that.
Thank you. With regards to the information he gave us, which again was brief because of the short time we had with him, he indicated that in spite of the wording that is generally accepted, as you've already indicated, at the UN level, that either New South Wales or Queensland in Australia have actually passed that type of wording that he's proposing, the abuse type of wording, into their law. And I asked him, and he couldn't give us an answer on this, if they had any indication of, one, whether it had been challenged in the courts, and two, if it had been more effective in dealing with it than the current wording that we're using, the child pornography type of wording that we're using in our legislation. And so I'm wondering if your department has looked into that as to what the experience has been in Australia.
Ms. Morency here looks into everything, and she
I was actually going to address my question to her because I figured she probably would know the answer.
Yeah, well, she
more so than you.
Well, thank you very much for that compliment. The input that I have received, and this has been consistent over the last few years, and I go back on this area to 1993 when we passed the first bill to on downloading child pornography. And I remember the briefings that I received 18 years ago on this, that the word child pornography captured a wide range of activity, exploitive of children. And I haven't changed my opinion on that. And again, with respect to the meetings that I've had with G8 justice ministers, the term child pornography is in wide use. One of the things that we are doing, and I'm interested that you raise this, is that we are trying to, as much as possible, facilitate the transfer of information between different countries. And I like the idea that we use the same term as that, because we, among each other, we encourage each other to give information as to people who are involved with this business. And so that among the reasons why I wouldn't want to change it, I don't want to further complicate that by start changing the definitions that Canada has. I think the term child pornography works for the reasons that I've said, and my recommendation to this government is to continue with that.
With regards to, you've not analyzed the situation in Australia as to whether it's been useful there?
Perhaps I'll ask Ms. Morency. I mean, for the most part, they use the term, but you indicated a couple of them, Australian states have changed the name, and she might be able to give you a little more background on that.
They've actually included in their statutes, Mr. Minister.
My understanding is his reference was to something in Australia. What I looked at between Monday and today, I think his reference was to the Commonwealth Criminal Code and Internet Offences. It's a criminal law that applies across all of Australia, although criminal law is a state power. In that statute, so a federal law, they do use both child pornography and child abuse material. I'm not sure if that's what he was referring to, because he didn't, as I understood from Monday, table any documents, but for different purposes. So that law does, in fact, still use child pornography, and in a broad sense, as our definition does as well. They use child abuse material to refer to, as I say, my understanding, a different form of material that depicts children under 18 as victims of torture, cruelty, or physical abuse. Quite a difference in approach. Again, I say with caution, because I'm not sure that's exactly what he was referring to, but that's what I'm aware of.
Let me just finish, Mr. Minister, then. I'm sorry, perhaps Ms. Morency, I should ask one more question. The brief that they put in, was it considered when this bill was drafted? I'm asking within the people who actually drafted the bill, did they consider the brief that...
I mean, I can just tell you in general, I mean, they obviously look at other like jurisdictions and other Commonwealth jurisdictions and other countries with respect to this. And again, the term is consistent with what we've always used in this country.
Those are all the questions I have.
Thank you. We'll move on to Mr. Deckert for 7 minutes.
Thank you, Mr. Chair. Minister, thank you for being here today, and thank you for introducing this legislation. I can tell you that I've been getting an incredible amount of email and telephone calls from my constituency from victims groups, and the general public telling me how important they think this legislation is. And I just think, as a member of Parliament, there's nothing more important that we can do than to protect children. so I want to thank you for bringing this forward. And I was amused and rather pleasantly surprised to hear my opposition colleague, Mr. Murphy, talk about the timing and his concern about moving quickly with legislation. You know, as we review all the criminal legislation that our government's been putting forward, he and his opposition coalition colleagues are consistently slowing things down. They like to debate the short titles of bills. They want them to be very, very precise, and they're willing to spend hours debating the short titles of bills. They like to move commas back and forth from paragraph to paragraph and spend a lot of time doing that. They like to...
Point of order.
You've previously, Chair, correctly steered people towards questions and discussion regarding the bill that is before us, not diatribes on previous bills.
I'm actually,
So,
Mr. Chair.
Is he got the floor or do I?
You've got the floor right now.
So I think in the interest of moving forward with this bill, I'm sorry everybody's hurt by the fact that this bill's only coming here 5 years after you were elected, but Mr. Chair, if we all want to work together on this bill, let's discuss this bill. He's talking about all kinds of other bills, and I believe it's out of order.
Well, I'm going to rule it's not out of order at this point in time. I'm prepared to allow him to continue. Mr. Murphy, as you may recall, I also allowed you to... I allowed you some leeway in terms of
J'aurais voulu parler
addressing the
avant que vous
minister.
rendiez
I talked
votre
about this
décision.
bill.
All right, Monsieur Menard.
J'aurais voulu parler avant que vous rendiez.
I would have liked to have had a chance to speak before you handed down your decision, but I think you're absolutely right. If you stopped using these titles as propaganda, we could vote for it. It's simply because it's systematically, you're using these terms of propaganda.
Chair, if I can beg the indulgence of my colleagues opposite, they'll hear directly how it's relevant to the legislation we're reviewing today. When we last met, Minister, we examined a number of witnesses who represented victims, and in one case, an actual victim herself, who told us her brave story, and told us why this legislation is so important. And I asked her about the timing of this bill, and you know, we've been going through the last several months or weeks in this country endless speculation about the possibility of a spring election, triggered by not certainly the government, but by other parties in the House of Commons. And there seems to be, you know, a concern on the other side that perhaps there should be an election soon. That election, if it were to happen, and I can tell you, people in Mississauga are telling me, please don't have an election. Stick to the work. Stay focused on the economy and protecting our families and our communities. And so I asked them, what do you think about the possibility of a spring election possibly derailing this bill? And what's your comment on the timing? And Ms. Campbell, who was herself a victim and represents victims of child sex abuse, said, I agree, it's been, while we've been sitting here talking today, how many children have been tortured or raped? It's high. So it's urgent. I really encourage you to hopefully please use us any way we can to support you to get the public awareness out on this. We would happily do that. Both herself and Mr. Rushfelt implored us to move quickly. I wonder if you could just tell us what you think of how we should deal with this legislation and the threat of derailing it with any kind of an unwanted election.
Well, thank you very much for that, Mr. Deckard, and thank you for your contributions to the criminal justice agenda of this country. It certainly very much appreciated. Obviously, anything that derails any of these bills and or slows them down obviously doesn't have my support. I mean, I was candid with people. There were people, for instance, over the Christmas break asking me why the bill getting rid of faint hope, the faint hope clause, why wasn't it finally the law of this country? I had to tell them. I said, you know, among other things that the Liberals didn't like, they didn't like the title, if you can imagine. I said, this is what we're dealing with. And so I think most people who follow this understand the challenges that we have. And so I guess my point on this, on all of these pieces of legislation, to better protect children is worthwhile objective of everybody, regardless of whether this is a minority parliament. And I know people said to me, this is a minority parliament. I always say that's no excuse not to stand up for victims or law-abiding Canadians in this country. So I'm asking your committee to do everything you can to expedite these things. This is better for Canada. Canada is a better country when we have laws on the books that better protect the children of this country. The two new offenses that I'm talking about, where you get two adults talking about setting up a child. I mean, Canada is a better place if there are laws on the books against this kind of activity. And so this bill stands on its own, as the others have. They're reasonable. Victims want this type of legislation. So thank you. Anything you can do, again, within this committee to get this thing through and get it into the House and not have it derailed for any reason, certainly would have my support, and I think the support of the people of this country.
Thank you. Okay. On when we last met as well, Minister, we talked to the same representatives of victims groups about the mandatory minimum penalties that are in the bill. And specifically, you know, we're often criticized by the opposition and others about the high costs of mandatory minimum penalties. You know, there'll be more people in prison. Some of these sexual predators will be off the street. They're going to spend more time behind bars. That's going to cost more money. We need more jail cells, perhaps more prison guards to keep them there off the streets, keep them away from our children. And I asked them if they thought, if that were true, assuming it were true that the costs of incarcerating people would go up, was it money well spent? And I can tell you that both Mr. Rushfeld of the Canadian Family Action Organization and Ms. Ellen Campbell, representing victims of child abuse, said yes, it would be money very well spent in their opinion. I wonder if you could talk about that and what you think the value of that is to the people of Canada, especially with respect to mandatory minimum penalties in this legislation, keeping child sex predators away from our children. Well,
Again, there are so many different aspects to this. First and foremost, of course, is removing some individual who is in a position to sexually abuse and exploit young people. I mean, that's the first benefit, quite frankly, of sentencing an individual and getting them out of the milieu in which they are exploiting other people. It also sends the right message out, in my opinion, that one of the amendments that we are making is to make sure that, among other things, house arrests or conditional sentencing, you heard me refer to that in my opening remarks, that this is not available. That actually hurts people's confidence in the criminal justice system. People who are in the business of sexually abusing children or assaulting people, if they get a conditional sentence, and again, nobody, I think, wants that kind of message to be sent out there. And so what the bill does, it's wide-ranging. It covers a wide range of sexual offenses, and there's a consistency with it. And I'm sure your examination of that, not just with me, with the departmental officials and the other witnesses, that will come through loud and clear, that it sends out a consistent message that this type of behavior will not be tolerated.
Okay, thank you. Mr. Lee, for 5 minutes.
Thank you. 5 minutes. Good. I just have to respond to Mr. Deckard, who seemed to suggest that opposition parties call on elections. He seems confused about it because, as I understand it, 100% of the time it's the Prime Minister who goes down to Rideau Hall and asks for the dissolution of the House for purposes of an election. So there must be a new constitution out there. Anyway, Minister, thanks for being here today. I would have thought, with all of your words about the importance of this and other legislation, you would have been able to give us more than an hour. But I've got my 5 minutes, and I know you have to hustle back to your office to work on some more Bill's short titles. So I'm going to ask you about one aspect of this, and it is rather technical, and it has to do with the potential for entrapment. It has nothing to do with the core purposes of the bill, which I'm sure all of the members agree with. And in Section 15 of the bill, that is, and that's really 172(2) of the Criminal Code, Section 15 of the bill, there are some new provisions that do three things. It adds a presumption. Section 15 adds a presumption dealing with what the accused believed about the age of the underage person, a presumption. Then subsection 4 removes a component of the mens rea defense, where it says it doesn't matter what you thought you knew unless you took reasonable steps. Doesn't matter what you knew. And then the next section of the bill says, and it takes away a defense, a further defense, to say it doesn't matter whether there really wasn't a victim at all, and it doesn't even matter whether there was a real person at all. In other words, there could be a totally artificially constructed scenario for purposes of entrapment, and I have no illusions, the police will be going after some bad guy. In all likelihood, they don't waste time on innocent guys. But let's say there is a bad policeman out there, and he decides he's going to entrap somebody. Let's just say, we all know there aren't very many bad policemen out there, but let's say there was one, and they decided to entrap. These sequence of sections set up by statute an entrapment. It's not like you use an entrapment to enforce a real offense or to investigate it. It is actually setting up statutorily an entrapment scenario, removing defense number 1, imposing a presumption number 2, and then saying it doesn't matter whether it was a fake person, a real person, or whether or not there was a real person or not. You're still guilty, not of committing an actual, what used to be a criminal offense, but facilitating, setting up, inviting. And to me, that is, we are setting up in our criminal code an artificially constructed entrapment mechanism where the person accused may have statutorily removed from him or her certain defenses. Now, the court can say, oh, well, I still can't accept this person is guilty as charged, but I don't like the look of this. Do you have have you walked through this? Have your officials walked through this? I understand why we want to get tough laws, but the procedures have to be constitutionally fair, and I'm nervous about this one.
Well, I can give you assurances that it is constitutional, Mr. Lee. I mean, one of the things
your previous assurances to me in the House have not always been 100%. You don't have a 1,000% batting average here, but that's okay. You're responding in good faith.
Again, Mr. Chairman, we're completely confident that all the provisions of this bill are constitutional. Part of what we are doing, you said, we're setting up a situation where people are discussing the potential or the possible sexual exploitation of a child. Part of what we want to do is to prevent this kind of activity to begin with. That's what we're trying to do. I said that specifically with respect to the new offenses that we have in here. We want to stop these individuals before. And I know the point you're going to make is that, well, if the person then commits the offense, well, then the elements are there. We're trying to back this up. Now, with respect to your concerns, with respect to entrapment, the entrapment provisions of the criminal code will continue to apply, and they will apply to all the provisions of this act. And so you would know, I'm sure, or perhaps the elements of an entrapment where the police go beyond just the discussion, and those provisions would continue to provide a defense for someone. But for that individual who's in the business of agreeing to exploit a child, we're going to stop them in their tracks right there. If that's what they're agreeing to do, that will be an offense in this country. Now, that individual said, I was entrapped or I was fooled or induced. I mean, those sorts of arguments can be made because the entrapment section will still apply. But for that individual who's agreeing to set up some child just because it's a police officer that they're in that discussion with, they will not be able to claim a defense against that. The entrapment will be there, but we're making it a crime to agree to start the exploitation of a child.
Thank you.
Yep.
Monsieur Lemay for 5 minutes.
Merci, Monsieur le Président.
Thank you very much, Mr. Speaker, Mr. Chairman, Mr. Minister. I calculated a few things. You know how many bills just have died on the order paper the day you decided to prorogue the House of Commons? Do you know how many bills died? Bills concerning justice.
Perhaps I'm sure some of the Liberals won't like you discussing other bills other than the one, but you're quite correct. I was very frustrated, particularly what was happening in the Senate. I mentioned the bill of protecting 14 and 15-year-olds. I'm sure the Liberals will tell you about their caucus members who were fighting us even on that one. And so, yeah, it was very difficult. And so I was one of the ones who applauded over a year ago when we appointed those new senators. And I tell you what, things are working much better in the Senate these days. I'll tell you what, I'm very pleased about that.
Monsieur le Président, est-ce qu'on peut dire au ministre?
Mr. Chairman, you know, if he wants to speak to the Liberal Party, I'd like him not to do that during my time, my speaking time. And also, the 44 seconds when he was speaking to Liberals, can I be credited those 44 seconds?
When we did the prorogue, it was the problems that we were having with the Liberal-dominated Senate. I don't want to be blaming you, Monsieur Lemay, for something that you're not to blame. Good heavens. I wouldn't do that.
Order. If I could have just one moment of your time. I think now's the time for us to dial down the rhetoric and get back to the bill that's at hand. So if I could ask all of us now to sort of treat each other a little bit more civilly, and let's get to the nuts and bolts of the bill itself. So, Monsieur Lemay, continue on.
Mais moi, j'ai rien fait, Monsieur le Président.
Mr. Chairman, I didn't do anything. They're arguing, the Liberals and the minister. I'd like my own minutes, you know. I'd like to be specific.
Referring to you, I was referring to all of us here. I think we need to tone down the rhetoric a little bit so we can get something done. So, you've got the floor again.
Bon, alors, Monsieur.
So, Mr. Minister, I read the bill, the CC-54. I read it closely, thoroughly. You know, there's certain people who will perhaps contradict me, but I'll tell you, it is a good bill, except for certain articles or certain clauses where you impose some minimum sentences for crimes that have already been committed. Is the objective here to prevent the courts from imposing the other kind, the conditional sentences or the suspended sentences? Sorry.
Have conditional sentences or house arrest in these particular areas. But again, thank you very much. I'm pleased to hear you say that this is a good bill. I mean, you've had some problems with the mandatory sentencing, but...
Donc, vous êtes d'accord avec moi?
So you agree with me?
Le pot va arriver.
I sent you some flowers. Now I'm going to send a brick. I think this bill should be separated in two. This is what I'd have to suggest. And you could study that with your officials. You want us to pass this bill, and I think that it's a very good thing to prevent the sexual exploitation of children by sexual predators. So we could pass Articles 13, complete Article Clause 13 that amends 171 of the Code. Could we do this? We could pass right away the complete Clause 13, which amends Clause 171 of the Criminal Code.
You know, I'm glad you've read this. You've read this very carefully, and the preventative measures that we have brought forward, you're on side with those. I say keep on going. You're just about there. Look at those other provisions that they send out the right message. Conditional sentencing, house arrest for people who sexually exploit other people. This is not good. Toughening up the sentencing. These are all steps in the right direction. And so I appreciate the fact that you like the new provisions that we are introducing into the criminal code. I say keep going. Sit down with your officials, and you'll see that all of this makes sense, and that this is all great legislation, and this country will be a better place for us.
Mais je vais vous dire pourquoi. Je vais vous dire pourquoi, Monsieur le Ministre, nous avons certaines.
I'd like to tell you why we have certain reservations about the minimal sentences, even in the case of sexual exploitation or sexual assault, because you do not give any discretion to the courts, to the judges. Mr. Minister, each case, as you know, or you should know, each case is different, is unique, but there are things in your bill that are quite important. You want to fight, to battle against cyber pornography, cyber predators. We're quite in agreement. Internet pornography, we're quite in agreement. But concerning the minimal sentences or compulsory sentences, well, even if this is passed, it doesn't mean that all those people will be in jails, but you talk about minimal sentences of 90 days, but have you discussed with the provinces concerning those minimal sentences?
This does give discretion with the judges, and it's perfectly in line with our roles as parliamentarians. We set, on every bill that I've been associated with over the last 25 years, we've always had maximum sentences. And I can tell you, Monsieur Le Maire, I remember one bill that I was the parliamentary secretary for. I had one of my own colleagues said, you've got a maximum here of 5 years. Why don't you make it, let the judge decide. Some judge may want to give this guy 6 or 7 years. I say, well, this is our role as parliamentarians, and we give those guidelines to the judiciary with respect to maximum sentences. And as you can see with this, we're giving that guideline with respect to minimum sentences. So on some of these, you could say, well, the mandatory penalty is 1 year. The judge has the discretion. He can look at that individual and say, look, 1 year doesn't cut it at all. 4 or 5 years is what this guy needs. And coupled with that, with changes that we've already had passed, getting rid of the 2-for-1 credit means that, time served, the time you get will be the time that you actually serve. So we've made that, and I think that, it's been consistent with that.
Thank you. We'll move on to Monsieur Petit for 5 minutes.
5 minutes. Merci, Monsieur le Président.
Thank you, Mr. Chairman. Thank you, Minister, for being here. And thank you to your colleagues, the officials. I would like to draw your attention to this point that was just discussed when we're talking about mandatory minimum sentences. I'd like to point out that I'm from Quebec, and we've discussed this issue with other members from Quebec. We don't all agree with the bloc. I'd like to point out that we are able to see that mandatory minimums are important. Why? Because like the woman who was a victim of sexual assault herself, we looked at the issue of children defined by the criminal code. I admire this bill. I also admire your consistency in the area of justice, because often we are reproached for being a law and order government. And I thank you on one point, because this bill is going to protect whom? The children of the Liberals, of the Bloc, of the NDP, and of Conservatives. It affects everyone. We're here to protect our children, not here to play partisan games. Minister, I thank you for this. Second, in my riding, as is the case in everywhere else, there have been a number of phone calls in these open line fora, and people talk about these, I would call them sentence bonbon, in other words, a joke of a sentence. It's almost this revolving door system. People end up in and then back out the next day. So it's unbelievable what ends up happening. Today, predators, you have lawyers, journalists, actors, doctors, everyone. These people are before the courts. I'm wondering this, and I'd like you to really look at this issue. Do you think mandatory minimums, that are the ones that are going to be created, would give people a trust in the justice system? I think we've lost trust in the justice system. I think people have lost confidence. And do you think mandatory minimums would allow people to gain that trust, to regain it?
I think they give, they help people have confidence in the criminal justice system. But I'm aware, and I appreciate the fact that there are people who disagree with this. And I think part of what our job is as parliamentarians is to put before Canadians really the difference of opinions that there are on this. We are very clear with respect to this. In this bill, that if you are in the business of sexually exploiting and molesting children, you're going to jail. Now, as you hear, there are those right here in Parliament who disagree with that, or they disagree with the mandatory jail sentences of that. But I think those are parts of the discussions that we have with the people of your province and other provinces to point out those differences between the approach of different political parties. We've been very consistent, as you know. We've made our justice legislation a priority all the way through. We've been consistent on that. We want to modernize the criminal code. We want to, as you say, increase people's confidence in the criminal justice system. And this is one more step in making sure that the rights of victims are understood, protected within our criminal justice system. And so, Mr. Petit, thank you again, and you and all your colleagues here for all your support of these. These are very, very important, and I wish you every success, as I do all the members of the committee, at getting this bill through as quickly as possible. Thank you, Mr. Chair.
Thank you, Mr. Minister. You were scheduled to stay for an hour. The hour is up. So we'll allow you to leave, and we'll have Mr. Matthias Viltort join us, and we'll continue our questioning. Mr. Lee, you're next.
Thank you very much, Carol. Very good.
Could I'll just wait for officials to.
Mr. Lee, we'll just take a recess of 2 minutes.
Okay, thank you. Yeah.
Bill C-54. We do have an operating budget request for the study of this bill. It was circulated earlier in our meeting. The total is about $15,000. If you could review that and...
Now,
all right. Thank you, Mr. Lee.
Could I ask on just briefly on that? Has this been spent, or because we had a panel first, right? Is this?
No, this hasn't been spent. This is on this bill.
Right.
For cost of witnesses.
But we had witnesses.
Yes, we have. So
none of this is that? You know what I'm saying?
Well, they haven't submitted expenses for reimbursement yet.
Mr. Chair, I can't hear you. You're not speaking into the mic. We can't hear you.
Oh, thank you. Thank you, Mr. Comartin.
No, my question is, it's not huge, but just like we're approving a budget, but it would seem to me if we've had witnesses already, some of them seem to be from away, the expense has already been incurred, perhaps not submitted, Mr. Fast, but how much of it is it?
It would have been incurred, but of course the witnesses didn't submit the expenses and then they're reimbursed. You understand that. I don't think we have an actual figure for what that would be because until those expenses are submitted, we wouldn't know what they are.
Fine.
Probably have a rough idea, but I don't believe the clerk wants to guess.
About it tomorrow because...
Yes, we'll discuss it tomorrow. Thank you. So we have a motion to approve this budget. All those in favor? Oh, sorry. Mr. Comartin?
I'm concerned, Mr. Chair. I have witnesses that I want called that are coming from both coasts. This budget, as passed, will not be sufficient to cover them. I believe the understanding is this will only be for the witnesses who've already testified?
No. The ones that are coming on Monday are also covered under this budget.
Okay. Well, I have others that aren't yet on the list since I didn't have any idea that we were moving on this as quickly as you want to. I'm just advising the committee that I will be seeking those witnesses, and obviously they'll need to be, their expenses will need to be covered. So I quite frankly think what we should do is put this off until we have our meeting tomorrow.
Well, Mr. Comartin, the request for witnesses was sent out by email, I believe, on the 7th or 8th of December, so that was over a month and a half ago. I believe the clerk also followed up with a phone call, and I see this as a recurring problem here at this committee, is that the requests go out, no one acts on them until we're essentially considering the bill, and we're close to doing clause by clause, and suddenly we have suggestions that more witnesses are required. Now, we have added more witnesses, but surely with a month and a half notice, we could have placed those into our calendar and also reflected those in our budget. Now, I've spoken to the clerk, and the clerk has advised that if there are further costs for witnesses, a supplementary or an amended budget would be presented to committee, and we could pass that as well. So what I'm asking for right now is, based on the witnesses we've already heard and the witnesses that are already scheduled, we have a budget here. If we could get that approved, knowing full well that a supplementary budget could be approved later as well.
On that understanding, I have no problem. I'll support the motion.
So we have a motion on the table. All those in favor? Opposed? Carried. Thank you, Madam Clerk. And back to our witnesses. We welcome to the table Matthias Villatort. And we're at Mr. Lee. Mr. Lee, you've got 5 minutes.
Thank you very much. Firstly, the minister referred to the entrapment sections of the criminal code. I presume that had to deal with entrapment defenses, either case law or in the code. Could you let me either refer to them now, put them on record, or if you want to advise me later, that's okay too. I would just like to have a chance to walk through those and compare them to the scenarios under this section.
The defense of entrapment is available at common law, so it's not in the criminal code. But to assist you with this, section 172.1, the existing luring a child offense, on which one of the both new offenses are modeled, does engage similar types of practices as you heard from the witness from the OPP on Monday. And I can, if the committee is interested, refer the committee to 2 cases where, in one case under internet luring, the entrapment defense was successful. In the other case where the entrapment defense was unsuccessful. So it is available, it is argued, and it is argued specifically in this context.
Okay. I'll think about that. Now, on to other issues. I notice in this legislation the government has put forward a bill here which switches the term, changes the term internet to telecommunications. That's an advertent changes. I think if I'm correct in this. The old so we're moving from the currently included term, used term, internet, doing these things on the internet, using the internet, and we've taken out the word internet and we've inserted the term telecommunications. Is that correct?
The amendment that you see in it's clause 15 replaces the word that is currently, for example, currently in the section 172.1, luring a child, currently talks about using a computer system within the meaning of subsection 342.1 communicates with. Replacing the language there and in the new offenses with telecommunications, because this is the language that's also being proposed more broadly in what is currently Bill C-51, was previously C-46, investigative powers for 21st century. So it's a consistency to broaden the capture of the type of communications that are at play. We're not, this bill, Bill C-54, still uses the terminology internet, as you'll see in the offense, and we use language that definition of the internet here, which is consistent with Bill C-30, I believe it is, the Copyright Act, also that language. So the intention here is not, the bill still does use internet, but the use of telecommunications would be consistent here and with its use in Bills C-51 and C-52.
Well, as I see that, and I'm interested in this just because we're passing legislation, and I want to know what is comprehended by the term we're using. We're criminalizing certain conduct. And it's conduct involving the use of telecommunications. So I understand what you've said. You're saying the change in terminology is for the purpose of imposing consistency between different statutes and the criminal code. Can I ask if the term telecommunications, the word now used in the bill, is defined already in the criminal code?
I believe the term is originating in what is now Bill C-51.
Oh.
You'll see the reference to telecommunications there, because this offense that you're talking about, which is now in Clause 15, was originally in the predecessor to Bill C-51. Was in C-46. So for consistency purpose, using the same language. The intention here, though, in terms of replacing communication, computer system to telecommunication, is to use the term that is the broadest term to capture all kinds of technologies that will fit in under that. So not just a computer system, for example, on your desktop, but maybe your iPhone that has a computer system telecommunication.
I understand that, but that's a significant change. We're going from a computer system, and we're now legislating all telecommunications devices. It would be everything. So I'm interested in that definition, and I'll have to go and read that definition, because obviously we've already passed a definition of telecommunication, means of telecommunication, in the other statute. So I will leave that. I mean, the answer is already in the other bill, right?
If I might also add, my colleague is just reminding me that the Interpretation Act also has a definition of the telecommunications.
Yeah.
So the intention here, you're correct, is
well, we've just criminalized, before what was criminalized, what you would send around on your computer. Now we've also criminalized what would happen on your telephone. Your
system, as defined by the criminal code, which is more than just a desktop.
Okay, but it was computer system. But now we've gone to telecommunications, which I'm assuming is everything. Everything that communicates.
It is broader.
Even an old telegraph is probably telecommunication. One of the Morse code things is probably telecommunication. But so we broadened the technological base that we've imposed the criminal restriction on. And that's okay. I will go and read that. I don't have any need at this point to propose an amendment. Now.
Thank you.
Well, I have another question.
I know, but...
Well, I'll have to come to it later.
Yeah, you'll come to it later. Yeah, that's fine.
Okay.
Okay, we're going to the government side now. Who's asking questions of the government side? Mr. Norla?
Well, at first I was going to be critical of my friend Mr. Lee because I thought he sat on the review of regulations for too many years, but he does raise a good point, because having been a court officer, one of the things that, of course, Defense Counsel always raises is the definition of words, and I thank him for bringing that up. But I hope, and this question will be sort of to the witnesses here, but I hope it's not in a way to reduce the kind or diminish the apparatus, the electronic apparatus, because the intent, I believe, and I'm hoping that our witnesses can tell me, can verify this, that the intent is as more and more information or the communication devices such as telephones become more and more mobile computers and able to do many more things, not only transmit pictures, but sequences of minutes of actual things happening. I would just, I guess as the minister said, would I be correct, Madam Morency, to say that what you're attempting to do here by using that term is to capture not only present but possibly future different types of communication devices?
The intention is to catch, yes, exactly what's available now and what is possible in the future in terms of identifying the nature of the communications that will be at play rather than just specifically how it presents today. But you're talking about the conceptual, and I'm trying to find for you right now the reference in C-51, the definition. But yes, it is to apply today and to what might come in tomorrow.
Yeah, because the bad people will find the flaws, because they tend not to be stupid, and if we don't try to at least keep up with it, as the minister has said, but as in my past experience, and going by the evidence that Inspector Scott Naylor gave us yesterday or the other day when he was a witness before us, related to those things, to those new devices. But in addition, and I think the previous question regarding entrapment was answered by yourself adequately, because I know that the recent jurisprudence has allowed some and disallowed others. So our judiciary is very careful to make sure that it is within the bounds of what they interpret the Act is intending to want to do. I sure wouldn't want, and my question to you is, did you think of this when you were drafting this legislation? You were aware that policemen do act as 5- and 6-year-olds in order to go out and mine the fields out there to find out who's trying to lure 5- and 6-year-olds into either viewing explicit or pornography or sexual assault, and also to lure them into actual meetings at malls and other places. So, would I be correct in saying that that was your intent with regard to the entrapment, is to cover that investigative technique?
Certainly, and it's as the Minister said, that the intention was to get at this preparatory conduct before an actual contact sexual offense is committed. And yes, of course, there is an awareness of investigatory practices that are used by police currently under existing criminal code offenses, as well as what we would envision for this proposed new offense. So yes, this was contemplated. As I mentioned earlier, I can leave the committee with a couple of cases that show exactly in the context of luring a child over the internet, where the defense was successful in one and unsuccessful in the other. Unsuccessful, I might add, with an accused who was a police officer, obviously not acting in the course of his duties. But I guess the point being, as Inspector Naylor had said, it is a common practice. We are aware of it. Obviously, police are trained in terms of what the lines are in terms of how far they go with the conduct. But typically, they do go on. If you read any of the reported cases, the description will indicate, for example, that a police was undercover in a chat room that was known by the name of the chat room and was frequented by like-minded child sex offenders and the like, and that they engage in that way. But again, the common law is very clear on the difference between entrapment and a legitimate investigative practice.
Thank you. Mr. Rathgaber or Mr. Woodward?
No, thank you.
No? Mr. Lee, you had some more questions, I believe.
Very much. This is another rather technical question, but it relates to the sentencing provisions for someone convicted of the crimes here in this bill, or the revised description of the crimes. And so it's in Section 26.2 of the bill, and that relates to Section 810 of the Criminal Code, which is the longest numerical description of a Criminal Code section I've ever seen, as Section 810.1 3.02a.1. So this has to do with the ability of a judge to prohibit a defendant from using the internet or other digital network. And I understand the internet part, but when you refer to when the bill refers to other digital network, I want to offer a scenario that for me creates a lack of clarity and might be problematic. Because we just refer to any other digital network, we're all aware that how many digital networks there are out there. It's all over the place. It's in hearing aids. It's in elevators, subway systems, automobile sensors, heart monitors. I mean, digital systems are everywhere. And if we, in setting out the penalties, the sentencing restrictions, are not specific, what if a judge simply says, I'll use the words of the Criminal Code, and you're prohibited from using the internet or any other digital system? That's in his order or her order. That, I suggest, is problematic because it lacks specificity about any of these other digital systems. And therefore, our failure to itemize the digital systems may handicap our judges in itemizing the restrictions in the sentence. And if the sentencing restriction isn't specific enough, it will fail at some point. I guarantee, judicially, on challenge, it will fail. So have I missed something here, or have we just sort of painted over in our zeal to impose more sentencing flexibility something here? And so could you comment on that?
I'll do my best. I'm not the technical expert on the cyber aspects of criminal law, and if the committee requests, if I may, I can obtain other assistance for you from one of my colleagues. But let me tell you, in terms of the use of the word Internet, certainly in developing Bill C-54, there was, we looked at what is the language that's being used now, whether in legislation or in practice by courts. If we look at reported case decision, court sentencing decisions, they do frequently use the language, the Internet. Sometimes you see it mostly with capital I, sometimes it's a small I, and it's sometimes specified to include other kind of specific modalities of telecommunications. The intention with the language used in Bill C-54, and we said, I mistakenly referred to Bill C-30 before, but it's C-32, Copyright Modernization Act, also uses the Internet or digital network. Now, my understanding from my cyber colleagues, the experts in this area, that Internet, small I, Internet, capital I, actually has a different meaning. And it has a different meaning for those that are most expert in this area. My understanding, as I say, is that early days when we started to talk about the Internet, capital I, was intended to deal with not just what we consider to be the World Wide Web type of network, but broader digital networks, because there are others that could fall within that. The intention with Bill C-54, for the purposes here, was to ensure that the courts are provided with direction to consider, in all cases, whether or not to make an order, and to make an order that is appropriate in the circumstances of that case. The language used in Bill C-54 refers to the Internet or other digital network in the broad sense, so it would include and is intended to include emails, computer systems, other networks of communication. It could be an iPhone, for example, where there's a telecommunication is being done through a computer system. The intention is to catch that because those are the tools that offenders are using to either access children or facilitate their offending conduct. So the intention here was to use language that is consistent with other federal legislation. And when we look at other federal legislation, the Internet is used in a few different ways. I mean, it's still relatively new compared to some of the other concepts that are reflected in law, but sometimes it's used to refer to a website. Sometimes it's used to refer to a modality for communication. The intention is to catch it all.
Thank you. We're out of time.
I just want to add,
we're out
okay.
of time. You'll get another chance.
No, but if I can just leave it with her. It's just my comment that without any redefinition, this would appear to cover off somebody using a GPS device. And I'll just leave that there as a suggestion, and I'm not looking for an answer.
All right. We'll go to Monsieur Menard for 5 minutes.
I could also suggest something about what Mr. Lee just said, because I share his concerns. But if we, for example, if we used something else, devices and other electronic mechanisms or tools as defined by the judge, that would be a little more specific. That means that in a specific order, the judge could be a little more specific, because in the case of a certain order, you think of certain specific things. But you may not be thinking about a heart monitor or something like that, a pacemaker. So I'll ask my question right away. Many of the mandatory minimums have been added to minimum sentences that had already been pronounced. after 2005, and there all the mandatory minimums concerning clauses 5, 10, 11, 12 of the C-54, which were introduced for the first time in 2005, the 1st of November 2005, was a study made at the Department of Justice or somewhere else, which would allow us to know what were the results obtained by the those mandatory minimums, by the implementation of those mandatory minimums.
Be receiving a presentation by colleagues at the Canadian Centre for Justice Statistics. They may be able to provide you with more specifics, but at a high level, if I may say, certainly between 2005, when 11 new mandatory minimum penalties were enacted in child-specific offences, and the data that we had to 2006 and 2007, we looked at what were the outcomes of convictions, sentencings, sentence imposed, the length of the sentence, other forms of sentencing that may have been used since 2005, and we also looked at the case law as reported to see what kind of changes have we seen made by sentencing courts. So I can indicate to the committee that certainly the sentencing courts have really shifted their thinking in the sense that since 2005, they appreciate that the 2005 amendments has a directive as a sentencing objective to give denunciation and deterrence as a primary consideration for sentencing in cases involving violence against children, importantly. Secondly, the mandatory minimum penalties have begun to have an impact, yes, in those offenses where they exist. So in the offenses, for example, prior to the MMPs where we would have seen possibly, for example, a conditional sentence imposed and afterwards no availability of a conditional sentence, we could see a decline in the percentage of cases where a conditional sentence was no longer available, wasn't imposed. We could see an increase, a slight increase in custodial sentences, and we could see an increase in fine and other dispositions. When I say slight, it's slight increase over that time. But what we didn't see was, when you look at specific offenses such as sexual assault, the general sexual assault offense, which the minister said is charged, in the 2008 data, was charged in about 80% of cases involving child victims. No mandatory minimum penalty, so you don't have that equal treatment. And that became apparent when we looked at the case law as it was reported. We also saw that when you looked at the length of the sentence imposed, that there were more sentences coming in at the low end of the spectrum, in other words, closer to the mandatory minimum penalty level. The other thing I would note for the committee's attention is that since that time, we've also had a few fairly important cases, decisions that have come down that have also contributed to what we're seeing today, but in the sense that the Supreme Court of Canada, for example, in the case of LM from 2008, has very clearly said a maximum sentence is possible in the case with the appropriate circumstances, and has noted the particular impact that the Internet plays.
Je vous interromps parce que on a tellement peu de temps. Moi, je pose une question de 10 secondes, puis on me répond.
You know, my question was very brief. Yeah, but that's, you're out of time. Yeah, that's it. You give us... I want to know if that had an effect on the number of crimes committed. That's what I want to know.
You've offered, I think, twice to give us those cases on entrapment, if you could give them to the committee. And can you give us that decision on LM as well?
I'm a bit concerned. The wording that's in section 13, which is will be 171.1 sub 5 point 2 or A2. on the bottom of page 5, or near the bottom of page 5. The dominant characteristic of which, near the bottom, the dominant characteristic of which is the depiction of for a sexual purpose. You're defining sexually explicit material with reusing the term sexual. What I'm concerned about is this: does that type of wording or that exact wording appear anyplace else in the code?
You have it in Section 162, very close in the voyeurism offense.
Right.
The change there is just for grammatical reasons. And you have similar language in the child pornography offense in Section 163.1.
Has that been? My concern is, we hear the picture taken of the woman nursing, so her breasts are exposed, the baby in the bathtub, and the fear of a parent or custodian, caregiver, whatever, being charged under this type of section. Have we had any of that type of abuse under those two sections?
Not that I'm aware of, and in fact the Supreme Court of Canada's decision in the Sharp case, the child pornography case in 2001, interpreted all of the components of the child pornography offense, including for a sexual purpose and explicit sexual activity, which again the courts would be informed by when they look at this, and similar language in voyeurism offense. So the Supreme Court in the Sharp case, basically its interpretation acts objectively viewed that fall at the extreme end of spectrum of sexual
Ms. Morency, if I could ask you to slow down because
Sorry.
the interpreter's having some trouble keeping up with you.
So the Supreme Court continued to say that depictions of nudity or intimate sexual activity, but not casual sexual contact, but it has to be for a sexual purpose. And the example that was provided would not fit within that interpretation.
But let's say you have a young child running around on a beach somewhere in the nude, and you have a predator taking a picture at that point. So not a custodian, not a caregiver. The Sharp case would exclude that from that picture. It showed up on the internet subsequently, would exclude that.
I think the case law is clear in saying that on its own, by itself, it likely may not fit within the definition of child pornography, but found together in the context of other materials that may point out the sexual purpose behind that photo, if that was the case, that could be an issue that could be argued. But that issue has arisen in the context of child pornography. The innocent baby being bathed in the bathtub in a picture, is that caught? And it's very clearly that that would not be. Is it possible that it could be? Again, as I say, the contextual approach in terms of all of the factors looking at it, it's very remote that it would be caught.
And as far as you know, it has not been up to this point.
My understanding is it has not succeeded. There have been some cases early on after the enactment of the child pornography offense, and it has not succeeded. I'm not aware of a case under the voyeurism offense where we've had there's been an issue with that. So in the context of Bill C-54's proposal, there is every reason to believe that a court interpreting the new offense would be very much directed and guided by Supreme Court's decision in Sharp and other case law under the voyeurism offense.
That's all, Mr. Chair. Thank you.
Thank you, Mr. Comartin. We'll move now to Mr. Norlock for 5 minutes.
Thank you. Derek, with all due respect, the digital devices, once again, I know we have lawyers here, and I'm not a lawyer, but I have sat for many, many hours watching many, many different cases, from sexual assaults to minor thefts, and I know about interpretation. But I recall time and time again, and my question to Ms. Morency would be pursuant to her experience with regard to jurisprudence when it comes to interpretation and the actual judge looking at the law, or the appeal court, even better still, looking at the law. Because I think, my fear is that if we go down Mr. Lee's path, we become overly prescriptive. And by virtue of that, I think the courts would realize that a heart monitor, a pacemaker, a hearing aid cannot be or would not be used in the transmission of sexually explicit pictures or sounds of that, or sounds of sexually depiction. So I really get concerned with that. So I wonder if honestly, I really don't mean to be insultive or anything else. I'm just so worried that we get into the tiny minutia, that we lose sort of the sight of things. And I think courts have already looked at these issues. And you mentioned voyeurism and some of the case law surrounding it. So I wonder if you could comment on being overly prescriptive vis-a-vis the effectiveness of the law, and what is your experience or the case law that you've viewed with regard to judges being able to interpret, or if a policeman became overzealous and laid a charge against someone who was on probation or who was on recognizance for being engaged in child pornography, and he happened to have a hearing aid, so the court's going to zap his hearing aid on him. That's number one. And the other, well, I wonder if you could just comment on that, because you might take a few moments for that.
Well, I guess my short answer is I would agree with the premise of the question, is that the hearing aid wouldn't be transmitting, communicating, providing access to the World Wide Web or other. I suppose there are some medical devices where they're heart halter that might be transmitting data to a recipient computer, but it's not providing access to the internet or other digital network, in the sense that it would provide the offender with the ability to access or communicate with a child or access illicit material such as child pornography. But I certainly appreciate the concerns expressed here. I will undertake to go back and provide, see if I can provide a more fulsome answer that would allay the concerns that you have identified. But as to the other part of your question, my understanding from reading a lot of case law is I have not seen a sentencing court express concern on how to identify what it is that they want to prohibit a convicted person from accessing. Typically what they do, the way that it's reflected in judgments, is that there's a sentencing report that's provided to the court, and submissions are made by the Crown and the defense to provide or restrict access to whatever devices or under what terms of supervision. And the intention with C-54 was to leave that flexibility in the hands of the court to craft an appropriate sentence in that case to address the concerns.
Thank you. That's all my questions.
All right, Ms. Morency, I'll just ask you to deliver the more fulsome report to us, to the clerk, and she'll distribute it to the members of the committee. We'll move on to Mr. Murphy for 5 minutes.
I have one specific and one sort of general question. The specific one is we had evidence from witnesses the other day, and I was struck by a comment but didn't know how to process it, that in Florida there's a 25-year minimum sentence for a child molestation conviction. The minister said you know everything, Ms. Morency, and I wonder if you could comment on the worldview of the severity of offenses in this realm. My second question is more general. The minister didn't bite on Mr. Rushfeld's comments and my question regarding changing the definition. But if you look at the code, and we all say the code needs a good look at now and then, between sections 150 and 172, these are the sexual offenses, public morals, and disorderly conduct. The way I'd read that is in descending order of severity or annoyance to the public, or in terms of condemnation, or condemnation. And it's interesting that when I say sexual offenses, and this bill is actually called sexual offenses against children, you kind of expect it to be in that first part, but it's actually under the public morals section. For instance, if we all think about the realm of offenses, in between 150 and 162, you've got sexual interference, invitation to sexual touching, sexual exploitation, incest, bestiality, voyeurism. And then we're on to 163, which is, tending to corrupt public morals, which starts with obscenity, so obscene materials, rather, comic books and all that sort of thing, and then child pornography. And I think my answer is that this has evolved, and child pornography wasn't as condemned by the community as when the code was written and amended as it is now. And it strikes me, if there's any order to the code, not for today perhaps, but in ordering the severity of offenses and putting them in the right section. There's some people who want to move offenses against animals as sentient beings from the property section to other sections of the code. So in the modern criminal code that we may get someday, should these sections, pornography, and especially this part of the child pornography section, should they be moved higher up in our order of condemned offenses?
In terms of your first question, the Minister was very generous in his remarks. I really don't know everything. I do know, and I can tell you that, yes, when you do look at the mandatory minimum penalties that may be imposed for different offenses in other countries, you will see differences. And in the United States, it's not a secret that there are definitely higher mandatory minimum penalties and higher maximum penalties for many offenses. In the context of, let's take one offense, child pornography, for example, because I believe the comments by the witness were to do with that. If we look at the United Kingdom's approach to child pornography, their maximum penalty generally is 10 years, no mandatory minimum penalty. In France, you have a range of maximum penalties as well, but no minimum penalties. Australia, you have a range of penalties as well. 10 years is the common mark for many of them, but no minimum penalties. If you look at the United States at the federal level, where they can deal with interstate criminal law powers, it's true that they do have some offenses that are, for example, in the child pornography using the males, a mandatory minimum penalty of 5 years and a maximum of 20 years. So there is a different approach for all the countries. The approach that you see reflected in the bill, as the Minister has said, reflects the Canadian context and the intention to bring some consistency across the board to all of the offenses where a child is a victim. I believe the second part was really more of a commentary rather than asking me to comment on the reordering of the code. Was there a question that you...
Do you agree with me?
Well, I think there's no question that the criminal code has not had a consolidated reform in quite a number of years, and as you amend it, you do lose some of the coherence in between.
Thank you. Thank you. Monsieur Lemay for 5 minutes.
Thank you. I have a few questions. Well, I'm having a hard time following what's in this bill. The more we talk about it, the more it seems kind of confused. There's cyber porn and that whole issue that we want to address through that change to 171. I really find it unclear, and I'm having some difficulty with it. I'd like some figures, though. And I'd like you to send us some figures. Can you send us the figures since 2005 up until today on mandatory minimums, sentences that were handed down for crimes for which you would like to see an increase in them, in these sentences? Can we get these figures? You have them.
the sense that you mean, and I think that I have not seen the presentation that my colleagues at Canadian Centre for Justice Statistics will provide. I'm hoping that they will provide that data that shows the baseline that I've referred to. I'm certainly able to provide you with those high-level numbers that I mentioned in my earlier response, but I suspect that the fuller presentation will provide you with greater detail, and perhaps if I could undertake after that, if there's other information that still remains outstanding that I could provide, I'd be happy to provide that. It's just that they have the access to the data.
OK. Est-ce que...
Okay. The purported objective under 171.1, etc., regarding everything over the web, from what I gather, is the government's aim is not really to sanction someone who's on the web, www.porn.org. That's not the point. The point is to sanction someone who uses or transmits or produces and then puts something on the web. That's what I gather from 171. The new section or clause 171 that would appear in the code. Is that correct, what I'm understanding? The idea is not to punish someone who's on the web. It's to sanction someone who is using it to then distribute, disseminate, send, transport, deliver. Is that clear?
More fundamental. The offense that's proposed in Clause 13 of Bill C-54, it may occur through the Internet, but it does not have to. The intention here is to, first of all, you'll see the definition of sexually explicit material excludes child pornography. So we're not talking about someone providing child pornography to a young person. What this offense addresses is any person who takes sexually explicit material, provides it to a young person for the specific purpose of facilitating their commission of a sexual offense against that child. How can that happen? It could happen, as you mentioned, that an offender is on the Internet and sends such an image to a young person. It could easily and very often happen in an in-person direct contact situation, the old-fashioned way, right? So we know from research shows, forensic psychiatrists that have appeared before this committee before have said child sex offenders often use these materials to lower the inhibitions of young people, to show them that this conduct occurs, that other kids may do it, or in this case that other adults are doing it, to normalize it, to make it easier for them to then sexually assault the child. So the proposed new offense in Clause 13 addresses that conduct, whether it happens in person or through the Internet or other means.
Moi, ce que je voudrais...
What I would like is to know this as well. Does this type of section exist or clause currently exist, a section that would currently exist in other countries, that has something like this that has been applied in other countries? Is this brand new in terms of the situation throughout the world, or does it exist elsewhere? And if so, can you indicate to us how it works elsewhere?
I can indicate to the committee that variations of this may exist in other countries. United States, at the federal law level, they do have an offense of using the mails to provide child pornography, for example, material to a young person. I believe there might be something similar, a variation of it in the United Kingdom's Sexual Offences Act. But the approach taken here in Bill C-54 is unique in the sense that it reflects the Canadian law with similar concepts and similar approaches. And as the committee heard on Monday from Inspector Naylor, it's an issue that police have long spoken about, that they would find very useful as another offense. So we do know it exists. We do know that other countries have approached it somewhat perhaps in similar ways, but not exactly like this.
All right, thank you. We're going to go to Mr. Deckard.
And thank you, Ms. Morency and Mr. Viltork, for being here today. You probably heard people talk about mandatory minimum sentences and how they would add to the cost of our prison system and our correctional services system. And of course, that's a policy issue that we as MPs are dealing with. You may have heard that when we last met, the committee heard from Mr. Brian Rushfelt of the Canada Family Action organization, and I asked him if he thought an increased cost of incarcerating people as a result of these mandatory minimum penalties in this bill would, what he thought of that increased cost, how we reacted to that. And he said, and I quote, "I think it's money well spent because if we can prevent one more child from being abused, we have made that investment worthwhile." Now, I'm not going to ask you to comment on that because that's a policy issue, and those of us who are elected here, we're the ones that should be dealing with those kinds of policy issues, and all of my colleagues on the government side believe that this is money well spent. The question I wanted to ask you is, you mentioned earlier something about U.S. mandatory minimum penalties, which are comparable to the offenses we're talking about here, and I wonder if you could tell us what you know about those U.S. mandatory minimum penalties and how they compare to the penalties that we're proposing in this legislation.
Okay. In terms of when we look at how our laws compare to those of other laws, I would suggest that comparison needs to look at not just what's the mandatory minimum, but what's the nature of the offense and what's the maximum penalty that's imposed in the other law as well, because the approach that's presented in Bill C-54 seeks to bring a consistency across the board for the offenses that we have here in Canada. And so if you look at, as you asked, if you look at, for example, at the United States, criminal law is a state power. If you look at the state law on child pornography or other forms of child sexual exploitation, you will find a range of penalties, both minimum and maximum, and a difference of approach. And I'm not in a position to go through all of that at this time, but as I had mentioned before, at the federal level, they do have federal criminal laws that address child pornography offenses. For example, 5-year minimum penalty and a maximum of 20 years for a first offense of distributing child pornography through the mails. Has to be through the mails to apply at the federal level to catch the interstate commerce. And a minimum penalty of 15 years and a maximum penalty of 40 years for a repeat offense of possessing or knowingly accessing child pornography that has been mailed, as an example. But as I mentioned as well, if you look at other countries and their approaches, there is a range of approaches, and Canada's certainly, as I say, the MMPs that are the mandatory minimums that are proposed in Bill C-54 are consistent with the mandatory minimum penalties that exist right now in the criminal code. So one of the proposals to add a 5-year minimum penalty for the offenses that carry a 14-year maximum penalty, for example, incest in Section 155, would be comparable to the offense that we have now in the criminal code in subsection 212 sub 2.1, the aggravated prostitution of a young person using violence. So the approach C-54 takes is to bring all of that together so you have that coherence.
In your view, are we being tougher on child sex predators with this bill than the average in say, North American, European jurisdictions, or are we in the same ballpark, or are we being softer on these kinds of criminals than?
As I said, the references to the comparable, for example, child pornography in Australia, United Kingdom, and France, no mandatory minimum penalties, but maximums around 10 years on average, and that's close to what we have here. But in Canada, you would have mandatory minimum penalties as well. And then at the other end, you would have difference, both minimums and maximums in the United States, and that's long-standing.
Okay, thank you very much.
All right. Next, we would go to the Liberals. Do you have any further questions? No? Okay, then we'll go to Monsieur Menard.
m'excuse infiniment.
I'm so very sorry, Ms. Morancy, but just to make sure you understand my 3 questions, I will ask them straight away, and then you can perhaps answer based on all the time you'll have left, and then I'll have used up my time, and it will no longer be within my time. With respect to the offenses and the mandatory minimums that were imposed in 2005, I'd like to know whether there was an assessment done of the effects on crime and the crime rate. I understand clearly there have been effects on prosecutions, but I'm wondering whether there has been any effect on the crime rate. And if these studies exist, could you produce them for the committee? Second, perhaps you're aware of Julian V. Roberts' study conducted by the Research and Statistics Division at the Department of Justice in Canada. It's called Mandatory Minimums in Commonwealth Countries, Some Representative Models. Could you produce enough copies so that it could be available? This report could be available to all members of our committee. Third, in this very study, we can see that in most Commonwealth countries, there are quote-unquote savings clause or exceptions that would allow a judge who believes that a minimum sentence would be unfair, unjust, that in a specific case, the obligation to impose a minimum would be so unfair or unjust that there could be an exception to it, so long as the reasons are set out in writing or orally. If you can provide us with some models of these clauses that exist in other countries of the Commonwealth.
All right, Ms. Morency, you can direct that information to the clerk.
If I might briefly respond on the first question. Did we undertake an assessment of any decrease in charging convictions of child sex offenses since the 2005 amendments? We did look at the outcome. We did look at the numbers of cases. I'm not in a position, I don't have data or study to provide to you. I think perhaps the Canadian Centre for Justice Statistics may in their presentation be able to partially respond to that. What I do have and can refer the committee to right now is the Jurostat that the Canadian Centre for Justice Statistics produced on youth victims of police-reported violent crime 2008. I'm certainly happy to provide that to the clerk. One thing I would note as a caution, and it's often difficult to make a direct causal relationship between changes in the number of incidents reported and specific legal law reform measures, because we don't know if sometimes it's an increase in reporting or an increase in incidents or a decrease, but that's a caution that exists. Secondly, as to the Julian Roberts study, we'll certainly, we may not have original copies, but we may have the photocopies that we can provide to the committee. And on the savings or the exception clause in terms of when other courts in other countries may have an ability to not impose a mandatory minimum penalty in exceptional cases, we'll undertake to do our best to pull some of that together for the committee.
Thank you. And then Mr. Comartin, until the bells ring, you've got the rest of the time.
It's just one question. It's really, I think, an amplification of Mr. Menard's. Did you do any analysis of the impact of mandatory minimums on the, and I'm looking here at a comparative study on the, in the jurisdictions in the United States where they are, and they are as substantial as they are versus, I guess, England, Australia, New Zealand, the countries that are societally most close to Canada. Was there any type of analysis of that done?
No. There is work, there is a bit of work that this committee will know that reference has been made to it on mandatory minimums generally, and more specifically underway in terms of firearms and the impacts they've had there. But we are not, I'm not in a position to be able to provide the committee with that information in the context of child sex offenses, beyond our own looking at the numbers and the ones that you probably will hear about on Monday.
Just as a supplement to that, in advance of this legislation being drafted, are you aware yourself whether there has been any of that kind of comparative study done specifically on child sexual abuse?
I'm not aware of it. I mean, I have researched extensively in the area, and if it exists, I'm not aware of it. It's possible.
Okay. Thank you.
Well, I want to thank all of our witnesses for appearing, and we will adjourn.